Ready? Exercise number 106 legal matter. Start. Questions relating to the vehicle or about the vehicle are matters of concern in chapter 4, under which the central government is empowered to set the norms for the fitness or the age limit of the vehicle. Chapter 5th, on the other hand, contains the legal regime with respect to operations of transport vehicles. It is under this chapter that the Parliament intended that there must be a provision for replacement of a vehicle covered under a permit so that the permit granted could continue and subsist till the end of its tenure. Chapter 4 and 5th operate in their own field, subserving the purpose and objects mentioned therein. Stop. Next para. For the reasons stated above, we are of the view that Rule 174 Sub-Rule 2 Sub-Clause C, made by the state government to enable replacement of the vehicle under a transport permit, does not impinge under the powers of the central government with respect to fixation of the age of the vehicle or fitness of the vehicle conferred upon it under sections 56 and 59 in chapter 4. The scrutiny under Rule 174 is only to enable the authority to ensure that the subsisting permit is not interrupted and at the same time public interest is not compromised by deviating from the permit. The rule will have no bearing on the power of the central government and as such it would not be ultra vires the provisions of the Act. Stop. Next para. There is yet another aspect which can lend a certain amount of clarity to this position. The vehicle which the authority may not approve for replacement under section 83 on the ground that it is older than the vehicle covered under the permit can be used as a transport vehicle within the state. There is no prohibition for such a usage as the said vehicle may continue to be fit and within the age limit prescribed by the central government. The rigor of Rule 174 Sub-Rule 2 Sub-Clause C is only in the context of a subsisting transport permit and not as a condition for transport vehicles as such. Stop. Next para. We may now come to the Act. Section 83 clearly predicates replacement of the vehicle by vehicle of the same nature. The legislature have used the expression purposely. They could have used various other expressions. To us, the expression is clear. Same nature would mean a bus by a bus, a minibus by a minibus, an air-conditioned bus by an air-conditioned bus, a truck by a truck, and not a bus by a minibus, and an air-conditioned bus by a non-air-conditioned bus or minibus by a regular bus. That is the only restriction. Stop. Next para. When in exercise of delegated authority, the subordinate authority, that is, the state makes the rules have to be consistent with the Act. The rules cannot override the Act or restrict the ambit of the Act. When the expression is vehicle of same nature, then if Rule 174 Sub-Rule 2 Sub-Clause C restricts that an older vehicle cannot be brought in. It would be restricting the right conferred to a person by the provisions of the Act. Surely, such an exercise by a delegate cannot be permitted. Full stop. Thank you very much.